wanted to spend some time doing some guided learning on the significance of the American Disabilities Act and why you as PTAs and future PTAs need to know about the American Disabilities Act. The American Disabilities Act was passed and signed into law in 1990 by President Herbert Walker Bush. The significance of the act was that before the act was signed into law, people with disabilities had less recourse in terms of being fired from employment, the discrimination in larger society in terms of access to building, discrimination in terms of access to education, and barriers to being able to access public places. The precursor to the act in some ways is the American Civil Rights Act, or the Civil Rights Act that was signed into law by President Lyndon Baines Johnson in 1964. But what's important is that for those 50 million Americans who have disabilities, without the ADA, there would be legal barriers and little precedent to remain employed if they were fired or had their job duties taken away, or they weren't able to participate in society. We think of the ICF model. I think that's a really important algorithm to think about and continue to go back to. So individuals that have a health condition, let's say whether it's a cognitive impairment or a physical impairment as a result of a trauma, whether it's happened at work or off the job, or have had have a progressive health condition, or a health condition that takes away their ability to hold down a job, use the Act to actually continue to work as able and to get some benefits, whether it be short-term leave from their job, or in the case of some, reclassification, a change in job duties if that's available, that they're able to contribute to the employer and to the company or to the work setting versus being simply terminated. And I think unless you've experienced a disability or have had a loss of function, or as if you know someone that's gone through this personally, a person who had, for example, a progressive neurological condition or health condition or a mental health condition that is no longer able to work, for example, now they have access to disability benefits, whereas before many individuals did not. So the ADA really looked at the big picture and who could qualify for disability benefits, and particularly those with health conditions which prevent them from working a job or being able to work a job for a period of time, be at a work site for a period of time. For example, you'll learn more about MS, for example, and there's a high percentage of people with MS that end up working part-time or reduced hours because it's that taxing effect of being at work for a period of time just exacerbates their condition, causes more fatigue, and can really be a setback for their health. And long term, most people with MS, high percentage, not everyone, but a high percentage, do go on permanent disability due to the nature of that health condition. But as you'll learn, with that condition, there are better treatments today than there was 5 years ago, which is pretty amazing. And there's been supplemental changes to the American Disabilities Act, the amendments, which really look at using the ICF model, which I think is quite wonderful. Looks at major life activity is considered. So, for example, if someone has a endocrine problem, which you'll learn more about next term, could be a condition that prevents them from working. So instead of having multiple health conditions, which before it was more challenging to get on short-term disability or long-term disability with only one healthcare condition, now with the ADA amendment of 2008, which wasn't that long ago, one health condition can potentially, right? There's disability lawyers and judges that decide if someone is able to go back to work or not, but can help a person qualify for disability versus before it was much harder. So why does this matter to USPTA? Getting back to this, we have to advocate for our patients. We need to inform them of their rights, especially if they're sharing information where they're having difficulty with employers related to discrimination or difficulties with accessing buildings, that they are empowered to know their rights under the law and to refer them to proper resources, which could be, in some cases an ombudsman, particularly for those that have long-term health problems, or someone in social work who knows the act perhaps better than you. But you should have a good foundation knowledge of disability related legislation that exists and people's rights, because you're often going to be the frontline person that they spend more time with than anybody else. So it's important that you know that disability is can be a physical or mental health condition. It's not simply someone in a wheelchair. It could be more hidden health conditions such as MS, for example, and what major life activities encompass. That's important. What is covered, so some physical impairments and impairments related to mental health. And you may question why some of these are related to health conditions. This doesn't mean that someone is enabled because they have trouble with alcohol to continue to be consuming alcohol and enabling them. What it says is that someone who has a health condition related to long-standing use of alcohol or long-standing use of drugs may qualify for disability under the law. It doesn't say that they guarantee they will, but they may. And that's the important thing, is not to look at this as black and white. What I should change is what can be covered in the ADA, because it ultimately goes to a judge. And then there's some things that are not covered and remain to be not covered. So what this means is that temporary impairment, like something very short-term, would not be covered by the Disabilities Act. And there's other protections because of the ADA, such as short-term disability that person may qualify for, versus long-standing chronic conditions. And to really know what is encompassed, and particularly being able to have access to public services, employment, public accommodations and services, and access to equipment, excuse me, or devices that assist in communication. And the 5 is a little bit gray. I actually may take that out because I really can't speak a lot to the miscellaneous. That could be, if something is not addressed in these first 4, it could possibly be considered by a disability judge or someone who practices law, employment law, not necessarily employment law, but just the legal profession in terms of protecting the interests of their client. And to know who must comply. So real small companies may not need to supply, but there can be a little bit of gray there, especially if it's real blatant discrimination. But certainly in terms of accommodations, larger companies, those with more employees, are obliged by the Act to create an accessible job place for people. And again, there can be some other, if it's we don't need to get into the nuances of the law, but if it's a substantial change in the workplace, then a person may not have to comply with the Act.